some periodic seminars on topics of special interest, and this one is about title issues. And I'm pleased to introduce Irene Del Bono. Irene is an attorney with an extensive background in property and environmental law. She was an assistant attorney general for 11 years, handling most of the state's property issues. And after that, she was director of land acquisition and later chief of encroachments with what is now known as the Department of Conservation and Recreation. Prior to her retirement in 2015, Irene was the statewide conservation restriction reviewer at the Mass Executive Office of Energy and Environmental Affairs. And I believe that's when I met Irene, when she was reviewing my CRs, probably. Prior to her, let's see, she's represented numerous private clients and assisted other attorneys in identifying and clearing up complicated title issues regarding boundaries, easements, roads, adverse possession, tax titles, coastal issues, tree rights, and public and private rights and property. So we're very pleased that she's lending her expertise to those of us who are gathered for this talk. She's going to take a couple of breaks for questions, and then there'll be a little more time for discussion at the end for those of you who are still with us at around 4:15. So I'll let Irene take it away. Thank you.
Thank you, Rob. This seminar is about how to find potential title problems in a proposed acquisition project. It's not meant to be a title exam class. What it is when you're first looking at a property or you see something and think, oh, I wonder if that might be worth protecting and what is it going to take to protect it. This will give you some of the steps that you should go through. Where do you begin to find out more? One good place is start with the assessor's office and the assessor's map to locate who the person that they have on record is responsible for the taxes. And also the assessor's map will help you identify how big is this parcel of land, what are its boundaries, who are the abutters. And if you think it looks like something you want to pursue, the first thing I would tell you to do is establish a chronology. Now, I will have a document that will be uploaded by the end of the week that has a lot of this information and has the key terms bolded to remind you. But the chronology is very important, and it's very important to put all the facts down, because if you get in the middle or the end of it and you say, wait a minute, I saw that somewhere, but you don't have a clue where, it's really difficult to go back over everything. So the chronology should include names, dates, and descriptions of the land, if we're talking about in any kind of deed or grant of an easement, etc. And you should also put down abutters. What I do on my sheet that I use is I do the abutters in a different color type, or you could do it, if you use black and white, you can do it in italics or whatever. And this will come in handy more often than you know. So you start with your chronology, and you've got the assessor's most recent information. Sometimes the land is in a trust. So how do you know who owns the trust, or who is the trustee, who has the rights to, for instance, sell the land or do anything with it? You can go sometimes to the Secretary of State, but I like to go to the record documents because someone has to sign the deed. So usually there's a name on the deed, and if there was a mortgage, there's a signature on the mortgage, and that helps give me a clue as to who an actual person that I can talk to. Sometimes when you look on the assessor's record, you'll see that it's in tax title or owners unknown, and we will get to that shortly. But once you find you have a name or the name of a trust, that allows you to then go to the Registry of Deeds, which has land listed by name, address, and you can also look up plans that way. The other thing to know about the Registry of Deeds, most land is what is called recorded land. So we get a deed, we go to the registry, we record it at the Registry of Deeds, but there's also registered land. If it's registered land, that means that it went through a process in the land court where the land court determined, after notice to everyone who possibly had an interest in the land, who actually has an interest in the land, what is the description of the land, and who is the current owner of the land. And then anything that happens after that goes on a certificate of encumbrances. So if you're dealing with registered land, you go over to the registered side of the registry to get your information. You should also always check the recorded side. I can't tell you how many times someone that was dealing with registered land had a deed and they ran in and they recorded it on the recorded side. So it doesn't show up on the registered side. It doesn't show up on the certificate of encumbrances. So if you're dealing with registered land, you need to check both places. And that's about all I'm going to say about registered land. It's presumptively should be easier. You should be able to just look on the certificate of encumbrances and say, oh, okay, here's all the information I need. But it's always best to check both sides. Now, on the recorded side, you start with whoever the current person that the assessors have, and you should look up the address if it's fairly new to see if there's a new owner that hasn't caught up at the assessor's office yet. And then you start going backwards. You look to see if there are any mortgages that are attached to that parcel of land, and you write down the information: who granted the mortgage, who is the person or entity that took out the mortgage, and then the descriptions. It's really important to keep track of the descriptions for each document that you're looking at. On my spreadsheet, I have a very wide column to the right where I put the critical descriptions so I can see if it changes at any point in time. The other place that you would be looking at is probate. If someone has passed away, there is often a lot of information in the probate documents that you would need to know about. Who was the land left to, or who is the executor or administrator? Those are the people that you might have to contact if the land is in probate. Very often, when you're looking at an empty parcel of land that hasn't been developed, there's usually a reason it hasn't been developed. And many times, tax titles and probates go back easily 100 years. When the town can no longer keep track of who the owner is, they sent out the tax bills. The tax bills didn't get paid for years. They don't know who the current owner is or where they live. So those are ripe for acquisitions if you're willing to do the research and the legwork. And this chronology that you will be doing will be very helpful to any title examiner that you end up hiring. It allows you, number one, to see what the problems are, to evaluate how big the problems are, what is it going to take to fix, how many back taxes are owed, what state is the probate in, is there a big challenge to a will, are there like 120 heirs that have ownership of the property, which for most developers, that's way too much for them to contend with, and probably too much for most of us to contend with. But that is because there's often a reason why the land has not yet been developed or sold. Also at the assessor's office, you'll see one name. The assessors do, by law, only have to send the taxes to one individual owner. So if there's 3 or 5 owners, you generally won't get that from the assessor's office, but most assessors now put the book and page of the deed, and you will get that when you go to the registry of deeds. And again, make sure you record each and every owner. And then the period of their ownership. When was it granted to the current owner? And how long did they own it? That period of time that they own it will be important because you have to go back to the grantor-grantee index, which lists all of the people that granted land to someone and all of the people that received land from someone. And you have to make sure that the grantor didn't, during their ownership, grant away some of the land or acquire some of the land. They might have acquired an easement. They might have granted forestry rights or mining rights. So it's really important, once you know all of the owners, to go back and check all of their names in the grantor and grantee index. And I go about 20 years prior to and beyond their ownership, because sometimes someone grants a deed of land that they don't own. It's in anticipation of their ownership. And when they later come into ownership, then the person they granted it to now has a valid deed. So always check before and after the period of ownership of the owner that you're looking at the time. Also, any mortgages, look and see if there are any, it used to be called marginal notations because they'd write it in the corner of the deed books, but now it's, everything's electronic. So you can look at any references to other documents that show up when you're looking on the registry of deeds to see what it is, whether it's a grant, whether it's a grant of a mortgage, whether it's a payoff of a mortgage, and note that on your chronology. Also, if you're looking and there's a notice of death, obviously you have to go and check with the probate court, look for whatever proceedings have happened, whether any estate tax liens have been signed off on, or a lot of times there's Medicaid liens. So it does take getting familiar with the probate side of the registry. Another thing to look for is a reference to any plans in any of the deeds. And a lot of times it'll say a plan to be recorded herewith. Those are the hardest things to find sometimes. So under plans, you try to, if it's fairly recent, you can look by address, look by name of owners. And unfortunately, it's not just the owner at the time of the deed that says a plan to be recorded herewith. You probably have to look at the previous owner or 2 owners to see if there are any plans recorded under their names. Sometimes you find it in a much later deed. Someone does the footwork and actually finds the plan and will put the plan reference in a later deed. But those are the things I find somewhat difficult to find when I'm doing my research. Another thing is if it's a subdivision plan, if you're looking at a larger parcel, say 40 acres, and it's been divided into a whole bunch of quarter-acre lots, usually there's a name of the subdivision. So it might be Sunnyside Farms. So you also need to look up under Sunnyside Farms, what was recorded under there, were any of the lots, interior lots sold? Was the name changed at some point? So often the development names will change over time. So that's another thing to add to your chronology to keep track of everything. And the most important thing here, besides the research, is keeping track of what you found and where you found it. If you find a plan, note the date that the plan was made and the date it was recorded. Sometimes there can be years difference. Each deed, most deeds nowadays reference the source of title. Sometimes they reference the source of the most recent title and also a much earlier title, because maybe a lot of things happened in between. So they really need to get a whole picture by referencing both. And that's really great. It makes it really easy. You just look up the book and page at the Registry of Deeds. But if it doesn't reference so many times, there'll be a deed and it says nothing about where the source of title came from. And it always, I find, happens to be like right about the 40s or 50s, which is the research when you put in the name of a grantor or grantee in the Registry of Deeds online form. They generally don't go back much further than the 1950s. So that puts you in a position of, if you're lucky and your Registry of Deeds has a grantor-grantee index, you can go back to the grantor-grantee index and look and see the name of the person whose deed you're looking at, and then see who granted them this particular parcel. So you can start again with trying to establish your chain of title. The other thing to look at is the grantor-grantee index says who gave away any rights in the land, the bundle of sticks. Full fee interest is everything, the whole bundle of sticks. But if they gave away an easement, if they gave away a right to forest, if they gave away a right to hunt, that is something that would probably be during the grantor's ownership. So you have to find that by looking to the grantor-grantee index under every single owner that you find. And if you find an interest like that, and we'll come back to this later, that's when your chronology of the abutting property may come in very, very handy. Let's see. Hold on. Oh, the other thing to know is if someone has been given the right to plant crops, and then the owner sells the land right afterwards, the person who planted the crops has the right under the law to wait until those crops are harvestable. So even though it's a new owner, it's subject to that pre-existing right. The law doesn't look favorably upon people that tell someone, sure, come in and plant 40 acres, and then I'm going to sell the land and the new person gets to harvest your whatever you planted. So that's good to know that if you see anything like that. Mostly you're going to be in the old deeds. So long ago, whatever was going to be harvested has been harvested. What if you don't see any easements listed? So you're like, oh, great. Here's 40 acres, no easements. I'm good to go. Well, in fact, the law says that the easement passes with the land, whether it's mentioned in the deed or not. So I believe that law was passed because so many people left the easement off of any deed that they were granting. Someone would be willing to pay a little more if there was no easement on it. And if they leave the easement off, they think, oh, who's going to know any difference? And I think what happened is the legislature said, no, we can't have this. We can't have, because the person who has the easement, let's say I'm granted an easement, I don't have any control over the owner when they go and sell their property. I don't have any right to demand that they include the easement in their deed. And so I'm left out fighting with the new owner who says, I don't see any easement on my deed. So it's important to know that that passes without mentioning in the deed. And if you see something on the land, one of the things they tell lawyers to do is go out and look at the land. Does it look like someone's been using it, like an adverse possession claim? Does it look like there's a trail through it, something that might have been an easement? And then you have to go back further until you find how, if there was an easement, how it came about, and you determine whether or not in the interim the easement has been extinguished. So don't think just because it doesn't mention an easement in your deed that no easement exists. That's one of the things I get hired for a lot, is to determine whether there's an easement, and if so, who has rights in it, whether it's been extinguished, whether it can be extinguished, or whether it can be asserted. So I'm going to break here in case you have some questions on what we just covered. Do we know?
Rob, did you have a question?
Yeah, I mean, I wondered if I could just ask you to kind of talk a little bit about the line between the level of inquiry that I mean, you're talking, as I look around who's on this call, it's a lot of land protection people or people who might be working on that side of the project. Kind of wondering about the line between where this kind of investigation stops and a title examiner's work begins. The level of work that you're outlining, I think, goes beyond what I typically did, but maybe I could have been doing a lot more than I did do when I was a land protection specialist. So can you just talk a little bit about that line between advanced investigations by a land protection person and a title examiner's actual work?
Well, the intent of this is to aid a land protection specialist and their land trust on whether to go forward to pursue an acquisition. Once the work has been done, you can turn it over to an attorney and a title examiner and say, here's what we found. Here's some of the issues that we noted. Here's my chronology. What do you think? Does this look like a problem, to fix any problems that arose? And I know land protection folks, even lawyers, generally wouldn't do this level of research. But I'm coming from the aspect of any land that's vacant today, that hasn't been developed, that's owners unknown or in probate or tax title or whatever, must have some problems, or they would have been auctioned off, they would have been developed. And so I like to know what I'm getting into. And I do this, I did this work long before I became an attorney. And it doesn't even mean that it's mandated that everyone go through this. I think it's important for you to know what kind of information is out there, where it is, and what to look for was kind of my goal. And I know of several instances where the research wasn't done, and then everyone got blindsided by this unanticipated problem. So I guess I just like to be super safe and secure about what I'm getting into, because I have a tendency to jump into things and then find that I bit off more than I could chew. So I don't know, is that useful to other people, or are you all finding this like, oh God, that's way too much work for me?
Catherine, did you have a question?
Yes, I do. I'm Catherine Howard from Newton Conservators. And this is certainly fascinating to me. I'd want to do this kind of research myself, just as a volunteer and if I was looking at a property. But anyway, I sort of missed what you said about the easement passing with the land, even if it's not mentioned in a deed. And did you say that's a state law?
Yes, and it's definitely a state law. I can't recite it to you at the moment, but I can add it to the document that is going to be posted at the end of the week. Um, I get hired by a lot of people. Title exams now only have through the Real Estate Bar Association and others. They say, well, a good title exam goes back 50 years. For me, 50 years is just not even close. And I find all the time easements that have been forgotten about that still exist. And I feel I owe it to my clients to do that kind of research. 50 years just, it's a nothing burger. But I would, I mean, one of the things is I also have lots of resources like for old maps, old aerials. So I also check those to see if there's any indication that there are easements that went through the land that no longer exist. And to give you one example, we had a tax credit conservation restriction up in I think it was Petersham. And it referenced a road, and there was no road. We couldn't find a road. And there were also forestry rights, which I'll be talking about. But I did some historic research, and it turns out that the little barely legible cart road that went perpendicular to the current public road was the original public road. And we were trying to find this back lot that had frontage on this road. And fortunately, I was able to find it and help the people get the tax credit that they were entitled to. And their attorney was like, well, we can just, deal with this in the deed and put this in. And I said, well, actually, the Department of Fish and Game bought the property next door. And if you do that, you're going to put a cloud on their title, and you're going to have bigger problems than you do now. And in the course of my research, I also discovered that the forestry rights were extinguished by merger because it came into the same ownership as the abutting lot that was owned by the person who had the forestry rights. So that worked out very well because, of course, it increased the value of the property that has 99 years of forestry rights versus property that doesn't is more valuable. So personally, I think it's important to do this research. And I think it's important what I'm trying to do with you folks is just get you to realize these little quirks about the law so that when you're looking at something, you'll immediately say, oh, okay, I need to take note of this, and then find out if you have a problem or not before you jump into something and then find it's an unfixable problem. And if you choose not to do all of this, that is fine too. It's like recording things at the Registry of Deeds. I always check the next day to make sure it got recorded because sometimes it doesn't get recorded or it gets recorded in the wrong place or something is wrong. So it's just a matter of how I think meticulous you want to be and curious. So I love solving puzzles. So that's probably why for me, it doesn't seem like a chore. I love making sure everything fits in place.
That's great. I see Mark Robinson has a question.
Okay. Hi, Mark.
Hi, Irene. It's been a long time. Yeah, talking about the 50-year look back. is very important in southeastern Mass because of sand rights, which are associated with usually cranberry bogs next door. And they're just working on a new property in Bourne that has a scoop out of it, and the scoop has a track that leads right to the cranberry bog next door. So it's quite clear to me that the cranberry bog uh, took sand because that's what you do with cranberry bogs is you spread sand out in the winter and stimulate growth. So, some of those sand rights might go back into the 1800s because that's when cranberry fever hit the Cape was 1870s and on. Um, but they don't go away until you extinguish them, isn't that correct?
Or if they're adversely possessed against, which takes 20 years and a lot of proof and a court action. So,
But the
yes,
ones that I've seen are just very vague. They just say the right to take sand in the adjoining property, and it doesn't say, a half acre or something. It just says the right to take sand, and that could be as much as
oh,
you want.
yes, those are difficult. Like,
So, yeah, I mean, we're trying to preserve habitat and water quality, and if you're going to mine the property, we'd like to know that before we spend a lot of money on it.
exactly, exactly. So that's how I am too. I don't want to jump into something, not knowing if there's a deep hole that's going to be a big problem. Anybody else?
Hi, yes, Abby McLean with the Rehoboth Land Trust. So you said that 50 years is typically, too short of a window to look. So how far back do you typically go? I mean, Mark's talking about going back 200 years. Is that like a anomaly, or is there context that you try to look for to inform the window?
I think at a point at which you feel confident that you're not going to find anything else. Sometimes if it involves ancient roads, you do have to go back 200 or 300 years to try to find the origin of the road and how it became public, if it did, or if it's private. But generally, like with easements, if I go back to 1850, say, and if there's no other strange circumstances, then I feel pretty confident that I'm not going to find anything else as far as an easement goes. And particularly if there's no indication on any of the old maps or aerials or any of the old documents that there were easements. So that generally I'm trying to find easements for people. So I'm like the worst enemy of the people that only did a 50-year title search because I find them all the time. And because I find them all the time, it makes me leery to just assume that there isn't one.
Okay, great. Thank you.
You're welcome.
John.
Hi, John.
Thanks. Hey, Irene, how are you?
Okay, yourself?
Pretty good, pretty good. Good to see you. One question I have is how would you, this may be a vague hypothetical, but curious what you think, just how would you approach a situation where you've got a potential project, potential property in mind, you pull the deed, and it's one of these like really old, just incredibly vague legal descriptions of the property. Like, what are your first steps there in figuring out what to?
All right, and there's no more current deed with a better description.
Correct.
So, two things: I would look for old plans and old maps, whether it be assessor's maps or whatever. Those are the easiest things to find. And the other thing is, if we don't have any luck, I actually helped DCR, the archaeologist at DCR, actually. They were trying to locate the bounds of a cemetery. And same thing, it was very vague. No one could figure it out. They'd been working on it for basically years. And so I said, look at all of the abutting deeds and the descriptions in those deeds, and your surveyor or engineer can back out a correct description based on the abutter's calls, because an abutting line is considered a valid boundary. And so if you drew a picture with all of these other abutting parcels with their descriptions, you would come up with the description of the cemetery's boundaries. I don't know, does that help you?
Yeah, that's very helpful. I think the last part you were saying too is pretty enlightening, just about, an abutting line is considered a valid boundary. So in the absence of a good description of the subject property, if you look at all the neighbors and they have better descriptions, that could be used to produce like a new description of the property, or what?
Absolutely. Abutters calls are valid, solid descriptions.
Okay, great. No, I appreciate that. That's helpful.
Oh, great. Okay, shall we continue on then? So now to go back to the assessors, if the parcel is listed as owner's unknown or tax title parcel from long ago, very often the owner moved away or passed away, and municipalities didn't have the ability to track their locations to send them a bill. So the tax bill is returned as undeliverable. What do you do in a case with that? Well, they start the tax title process, but most of them don't get around to completing it, especially for low value land, unless it's someone that's very interested and says, hey, I'll help fund that tax title if you will complete it. So we have all of these incomplete tax title parcels, which means they're still owned by the original owner, subject to the municipality's lien. There's several ways to acquire these. If the municipal lien has been foreclosed on, then you can request that they put that land up for auction. And if it's been foreclosed on, they have good title. All liens, all prior owners, after 1 year are dispensed with. The other thing, and I've acquired property myself this way, is, and also with a caveat, if you put it up for auction, it's public auction. And so you risk having a developer bid on it. So one good thing is if you have a good relationship with the town, or you can convince them or their open space committee or their conservation commission to do it under a request for proposals. And the statute for selling land, municipal or government land, allows for this. The municipality can say, oh, yes, we need to protect wetlands. We need to have more conservation land. And so they can put up a request for proposals for this tax title land, saying for conservation purposes. So developers aren't going to bid on it. Only people interested in conservation will. And because it's restricted to conservation purposes, the bids should be a lot lower. So that's another way to acquire tax title land. You can also purchase the lien from the municipality. You can request to buy the lien. A lot of times the municipalities want to bundle them, but it is a good way to acquire it. You give the municipality whatever they're requesting for the back taxes, and then you pursue foreclosing it in the land court yourself. Now you take a chance, you're going to go through all this, and maybe the owner will show up, but if they do, they have to reimburse you for all your costs. So it's a lot of investors are doing this. They're bundling many tax title parcels and then going through it like assembly line fashion so they can acquire the land. The other thing that you do, and I did this myself, is you start doing some research. You research genealogical and historical information. You look at old deeds and you find out if the last person that was taxed owned other land, and look at those deeds. Very often, the person that was taxed was no longer alive, and their heirs inherited their land. And so they sold it, and you'll find an affidavit of death. You'll find who the heirs are that are listed, who had the authority to sell the land that was in the estate. And then you do a Google search and you find these people. Are they still alive? Are their children still alive? Because they're heirs to the heirs. And the smart thing to do, which I didn't do on my last one, is get a municipal lien certificate first. You go to the town and you say, how many taxes are owned on this parcel? And they'll give you a municipal lien certificate that says how many taxes are owed. So then when you find the heirs, you say, there's this property, it's landlocked or whatever the problems are with it. There's old taxes owed on it. Would you be willing to deed it for me for, say, $5,000? And if they say yes, and you ask them, are there any other heirs that I need to contact? And then you have them sign the deed, you give them their $5,000, you run to the registry and you record the deeds. And then you go back to the municipality and say, here's the municipal lien certificate. It says $5,000 is owed on taxes. Here's your $5,000. And here's the deeds. I now own this land. So that's another way you can do it. But it does take the research. And like I said, I enjoy the research. It's a challenge. So for me, it's kind of fun to do, but I actually have 4 building lots that I got that way. So I think it's worth it. I'm not developing them, by the way, but so that's another way that you can think about. Obviously, you probably want to get an attorney involved at some point with that, but just to be able to say to the land trust, hey, that parcel we've been looking at for the last 15 years, well, here's the deal. The owner died in 1940 and his heirs in 1950, through probate, sold all this other stuff, but they never sold this one. And I found through some research that 2 of them are still alive, and the other one, they have a child that's still alive. Do you want me to see if there's any interest in them selling it to us? So that's another way to deal with these tax title parcels and old probate parcels that just seem to lay there forever without anyone having, they're not protected, except until they're protected as long as no one does the legwork, shall I say. And then to get to all land, you should research the history of the parcel. Was it a farm? What was it used for? Was it used for a lead factory where there might be contamination or railroad? Was there a reference to anything that says there's an old family cemetery and you got, Ma and Pa Jones that are buried in the center of this that you have to account for? That's a really important thing to know. And if you're a history buff like I am and enjoy reading about those things and seeing what happened in the past with the land, that's great. If you're not, it could be very tedious. So you need to find someone who's curious and interested and wants to look for the information and follow it down. Probably someone with a really good ability to focus in on minutiae. Old newspapers, they're online now. You can find so much in old newspapers. Local historical society or historical commission or some old timer that remembers. We have it's at the corner of Wellesley, Natick, and Dover, Elm Bank. And I remember driving school a school bus there and bringing kids to a school there. No one here had any idea that there was a school there at one time. And it actually started out in the, I don't know, late 1700s as a school. So it's fun to know the history. And then each owner, when you do a genealogy, we had one, I was trying to determine if it was a great pond. And you have to prove that it was 10 acres or more in its natural state. And that's pretty hard to do when you're going back to the 1600s. But fortunately, I found the person who owned the land around there had fallen through the ice in the winter and drowned. And so it was obviously no one could rescue him because the pond was so big. But since that time, with eutrophication, the pond was pretty much a meadow with a tiny little puddle in the middle of it. But I was able to prove that it was a great pond because through the genealogy and the witness testimony and the affidavits of his death, that it was a pretty good sized pond back then.
Irene, I don't know if you would take a question from Mark at this point.
Sure.
You want me to hold it? Go ahead.
Well, I didn't mean to interrupt. Just this thing about tax title properties. So one of our land trusts on the Cape actually funded the town's title research. So through a fund to the town that was dedicated to researching these owners unknown and just abandoned properties. One of them was key, and we had the town do a lot of research, probably $10,000 worth of research. And then the town submitted all that information to the land court in Boston in order to get the foreclosure decree. And apparently, it's public information. And a developer scooped in, contacted the owners that were in the file, bought the property, and we ended up having to pay hundreds of thousands for the property that we thought the town was going to get for 10,000. Have you ever heard of that? That this is public information that people can scoop it out from you?
Yes, and that's the danger of paying the town to do the title search because that's all public. It goes before the select board. I think that's how I found out that the land we built our house on was tax title land, and we acquired that. But if I'm a big fan of doing your own research, doing it on the sly until you have as much as you need, and then securing it, which is like what I did with the heirs, so no one could grab it from me because the lots we have are pretty valuable.
So doing that work, doing that work before it gets to the land court, because once it's in the land court, it's public. Is that right?
Well, once it's before the town, because the town usually asks the person who's examining those old titles how their progress is. At least in my town, that's what they did, and how much money they're bringing in, etc. So if you do it the way where you purchase the lien from the town, then you have that control because you can go to land court and you can foreclose on the lien, and you are the owner who can do that. You're the owner subject to the tax lien, and that's a way to keep developers from getting their hands on it.
Interesting. Thank you.
You're welcome. Yeah, I know with all the work I did, I wasn't about to watch everything slip through my fingers and have someone walk in and say, thank you very much. I'm going to build an apartment building next to you now. All right, and we talked about rights such as easements, forestry, hunting, mining, etc. Now, a lot of lawyers believe that you no longer need in your granting clause to reference, heirs and assigns and all of this other language, this archaic language that used to be in there. But what they don't notice, and I've had to point out to many of them, is if it's less than a full fee interest, you need to include heirs and assigns. That's really important. And I know when we were doing the conservation restrictions and I added that, people didn't understand, but once they understood, they agreed. And why is that important? Because you're not going to be granting land. It's important because if you see easements and other types of rights, and it doesn't say heirs and assigns, generally that is interpreted as personal to the person it was granted to. So it's not a pertinent, it doesn't pass with the land. The person you granted the rights to can't pass it on to their heirs. They can't assign it to someone else. It dies with them. So it's really important for any lesser interest that you look for that language, heirs and assigns. There's one or two cases more recent where the court has said, well, we'll go by the intent of the grantor. And the intent was that they be able to use this down through time. I think in one case, it was the ex-wife of the grantor. But generally, if it says heirs and assigns, you've got what's called an easement in gross that the law doesn't protect as well as an easement that's attached to land that benefits land. So again, like I said, these are just little tricks I want people to be aware of. So when you're looking at something, you wouldn't even have a clue as to what it means to have it or not have it. And I'm hoping that this will let you know that that's a good thing. If you see heirs and assigns is missing, that gives you one more little bit of leverage to undermine those rights or get rid of the rights. Oh yes, and if there is an easement or something of that nature, it has to benefit other land. If it's an appurtenant easement, it's supposed to name the benefited land. And if it no longer benefits that land, that's one way you can extinguish it. Now that's all stuff for an attorney, but what you look for in these old deeds is, does it say that it benefits Jim Smith's property? If it benefits my neighbor, so that they can bring their cows across my land. If it doesn't have that language, make a note of it on your chronology, because that means something. I mentioned how important your chronology is for neighboring parcels, and that's what we're talking about. All of these rights that may have been given that take away from the full fee interest. If you notice that the neighbor and the owner of the property subject to the easement were the same at any point in time, that extinguishes the easement as a matter of law. The easement disappears because if you own both parcels, you don't need an easement to go from one to the other. You have the right to do that if you own it. And so if the parcel that had the easement is then sold and will no longer be owned by the same owner, the grantor has to put in there that they are granting an easement. It doesn't like revive the easement so the easement comes back. And if they fail to put in that part of this grant is they're granting an easement, maybe they'll say, I'm granting the easement as it appears in this deed or on this plan. And that's the only way you can bring that easement back, or mining rights or forestry rights, once you've come into common ownership. Trust me, I made a Boston developer extremely happy because he was being threatened with a lawsuit, and people were saying they had an easement across the land he wanted to develop. And it took me about 15 minutes to figure out that they didn't have an easement. And I don't expect everyone to know the law or remember the law. I just would like you to remember that there are ways to get rid of easements. And that is one of the ways if it ever came into common ownership. Because you don't want a 40-foot road going through the middle of your conservation land because someone has an easement that goes to their backland. That's something you want to try to avoid. The other big problem is nobody reads cursive anymore. So you'll have to find old folks like us to read these old deeds until they develop some kind of a computer program that can do it for you. And you still have to double check. But so I'm going to open this up to questions. Let me see. I have some other notes just to make sure. Intent of grantor, that I covered everything I wanted to. Oh, yes. So if you're trying to figure out the meets and bounds of a parcel and it fronts on a road, and most roads are easements. They aren't taken in fee. In other words, they're not owned all the bundle of sticks. The town or the government just has an easement over your land. And the funny thing is, when you go to check your boundaries of the land, people are like, well, should I go out to the middle of the road because I own to the middle of the road? But no, generally the meets and bounds only go to the edge of the layout. So you won't find, or you would rarely find, where they've included the land under the road in the description. See, fee simple. 10. I think that's everything I wanted to cover. Yes. Any questions? Any problems you're trying to figure out that maybe I can help with?
Kelly, is that yeah,
Sorry,
hand
I
up?
meant to raise my hand, but it looks like I'm applauding. I am applauding as well. Thank you. This has been super useful. So I've done these chronologies on parcels before, and they get really complicated really fast and hard to keep track of. So I'd be interested to see if you have like an example of how you organize the information, especially when you're talking about like then doing the chronology of an abutting parcel. I guess that kind of branches off the main document.
Well, I find using color for the text is helpful. So if I'm looking at 4 chains of title, and very often when I'm looking at something, I'm looking at almost whole developments to see who has what rights where. And so color helps me. I might do, the main character will be in black, and a butter to the right will be in blue. And I keep a column for the address of the property, so I can always look down and make sure that the addresses match up. So what I can do is when I submit this document, I'll submit one of my spreadsheets so you can see how I do it. And I'm going to write that down now. You have to do it your own way. I'm not very organized in a lot of things, so I have to find ways that are simple and make it easy for me. And that's what I have found. You might find your own. Some people use different pages, but I just have this massive sheet that I can just look down right away. And if I'm following a particular title, I just look for all the blues or all the purples. And I find that works for me. So I will send a spreadsheet so you can see how I do it. Will that be helpful?
Would be great. Thank you.
Kate, go ahead.
Hi, Kate.
Hi. So I'm not sure how helpful this will be to a lot of other people in this call, but I work for the City of Boston's Parks and Recreation Department. And one thing that we're looking into at the moment is like formally protecting a lot of like medians or grassy islands or sort of like triangles and intersections that are all technically part of the right of way, but are sort of functioning as parks, and trying to make sure that they're protected from any potential road reconfigurations or things like that. And we have like a whole big long list. And like, I was wondering if you have any sort of advice for ways that I could find some of these potential like title issues to figuring out how to prioritize which parcels might deserve a full title search by like a professional, and whether because it made me think of this when you spoke about just now owning the right of way, and most of it is an easement. So I'm wondering if there's sort of, I guess like some telltale signs of like, oh, like this is definitely going to be an absolute nightmare because I can easily look at this and tell that it's full of utility easements, or like if there are sort of ways to get into that research without hiring a professional.
Well, even worse, if it's an easement, that means that you have hundreds of property owners owning the underlying fee along there. We have the same problem with rail trails, where the railroads had easements across everyone's property. And so when you go to do something, you have property owners on each side, all the way up and down the easement. The law, as far as transportation goes, allows for new uses. For instance, when the old boats in the canals in Worcester were replaced with a railroad, and the property owner said, hey, this is a new taking, we're entitled to more money. And the court said, no, it's still under the rubric of transportation. In Boston, when they put in the electric trolleys, and people said, no, or in the subways, same thing. They thought it was a fresh taking, and the court said no, because the taking was for the purpose of transportation and for the modes of transportation as they advance. So that's the easy thing. To change the use entirely to conservation, and I assume you're not talking about disrupting like the utility lines and drainage and everything else that's running under them. If you're talking about the surface only, I imagine it could be done as under the rubric of an enhancement to transportation, maybe even a safety factor with that. But I'm not sure if you're talking about doing a taking and making it full conservation land. And if you did, it would have to be subject to the prior uses, or it would be a boondoggle. I mean, with having to pay people for making changes. For instance, let's say one of the systems goes, it runs down the center and you've made it into conservation land. Well, now you have Article 97 to contend with, and can they open it up? Well, yes, their rights are prior rights, and they have the superior rights to whatever you do. So, and I know you have great counsel with the city of Boston, but that's kind of the things that I'm seeing. I think if you do like the Rails to Trails program did, where they said, hey, we're preserving this for future transportation, but our current use is going to be for people being able to ride their bicycles and walk. But basically, this is like being preserved for transportation, even though we're using it for something a little different now. That's probably how I would approach it. But I'm not saying that's the only way, but that's the easiest way I can think of right now. I hope that's helpful.
Okay, thanks.
Meredith.
Hi. I have sort of a title for dummies question, Irene, so forgive me in advance. But I'm a land protection specialist, so I've been working on that side, and I don't have a legal background, and so I personally struggle with when I'm even like looking for something at the registry, and I might even have the book and page. Sometimes it takes me like 16 tries just to get there. So I don't know if this is really the right question to ask in this forum, but like if you have tips and tricks for just like navigating the registry and probate you were talking about, like that's just kind of a whole new area for me that I don't really know how to find things. And I think just becoming a little more literate so that I know even what I'm looking at sometimes when I might be looking at the thing I need, but I might not know it right away. So I guess just tips and tricks for someone kind of coming into this, learning some of the legal terminology that might help and just finding it. I'd be super interested in if that's anything you can offer.
Well, most of the registries give classes. And if your particular registry doesn't, you could check with another registry on how to find things. And I started out the same way. You know, I was I had to share this room with these ancient books that would make you sneeze every 2 minutes. And it was also the tables that were being used for the people in the midst of divorce fights with children. And it was, my husband came with me one time. He says, I don't know how you can stand it. He says, it was really emotional and everything else. But, the book and pages, they're sequential. So they're chronological and sequential, but they aren't always where they're supposed to be. And as the registries grew, they'd have little alcoves and other places. So you'd be on the 3rd floor looking at something, then have to go down the basement, then go back up to the 2nd floor to find it. And the one good thing is that in the old days, there were lots of title examiners there, and they were always willing to help. But the people that work at the registries, I have found them to be, they're lonely. They miss everyone coming in there, and you go over and ask them a question. They're like, oh, they can't, they're just so glad to have a human to talk to. And don't hesitate to ask people. Some things are weird, and you just have to keep asking people until you get to the right person. I've found deed books on top of coat closets that and one of the chief title examiners at the land court that I was up against, and I told him, I said, if it can be found, I'll find it. And I went right across from land court to his office, which was right next to my office at the AG's, and I brought it to him and I said, I found it. It wasn't a taking. This guy gave him a deed. So I told you I would be able to find it if I looked hard enough. And he says, well, I wish you wouldn't look so hard. But that was just a fluke. And another case, the lunchroom, they had these big drawer bureau things where they had all these old plans. So when I asked, were there other plans, somebody says, oh, there's a bunch in the lunchroom. And I went in there and I started opening drawers and looking through the plans. And sure enough, I found the plan I was looking for. If you're in the really old weeds, the archives during the Depression, they hired people to go into like town halls and government offices, and they would make lists of what was in there and where all these papers were located. So I'd go there and then I'd call up the town's attorney and say, well, I think it's in the south corner, 3rd drawer down. You want to take a look? And he'd say, how did you know that? But it was only through years and years of being very curious. And I used to lead seminars on where to find stuff. I would take people for walks all through Boston, and we'd go to all these different buildings and I'd show them all these nooks and crannies. So don't get discouraged. I think just ask the people that are working there if they could, help you out. And if you get, one of the, nasty ones that snaps at you, just go to someone else. because everyone has a bad day sometimes. But I have found, I was just really shocked the last few times I've been in, and they're like, oh, we're so glad someone's coming in. So I would encourage you to do that.
Thank you.
I see Jim Como has a question.
Hi,
I
Jim.
do. Hello, Irene. Long time no see.
I still
Thanks for
have your
doing this.
four-leaf clover.
My question has to do with probate court, and can property change hands through the filing of a will, or does that just authorize an executor to deed it out?
It all depends on the wills. Some wills give the executor the ability to immediately take the land or the house or whatever and do with it as they wish. So it all depends on the language of the will.
Okay. So, and how does one go about starting at the probate court? You know, do you need a former owner's name, and then you go to the desk and say, so explain that a little bit.
Yeah. So generally, exactly, you have the former owner's name. It also helps if you have the probate number, but they can look it up for you, and then ask them to direct you to. They generally don't direct the public anymore into where these places are. Too many documents went missing. So generally, you go up to a window and you have a little request thing, and you say, I'm requesting, probate number, blah, 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 with whatever the person's name is. And then you wait a little while, and next thing they'll call your name, and it will come down, and you look at it and examine it, make any copies that you want to make. Yeah, I mean, I'm not an expert in probate, but I know enough to figure out how to access where a lot of times they look like ammunition boxes with all of the documents in them, and you get them and you just start looking through and reading them.
So how
I'm
does one get
assuming you're talking about old probates, not new ones.
Well, exactly, old ones, because some of these owner unknowns in the middle of nowhere, I suspect that it was, subject to a will, a century ago, and the land was never actually deeded out, and so the assessor lost track. How does one get a probate number?
Yeah, the other important thing is don't assume that the person's probate was in the same county as where the land is.
Oh my goodness. Yeah.
Yeah, sometimes they were in another state. So that's where some of these histories and newspapers, if you get a subscription to one of the good old newspapers, and you can look up their obituary. I found a person who was actually buried in my town. The town didn't have a clue that they were buried in the cemetery. But I definitely, the Boston Public Library, I haven't been there in years, but you used to have to slog through page by page with their microfiches. Fortunately, most of that stuff is much more accessible online, and they have free sites like Family Search, Ancestry, and now they have, what is it, Wiki something to do with Ancestry. And it's much easier to find these people, find out where they passed away. And sometimes it says where they're going to be buried, but usually where they passed away is a good clue.
This is a nightmare. I think this is well beyond the skill set of the average land protection person.
Yeah, well, yeah, unless if there's someone that has dabbled in genealogy or anything of that nature, they can pick it up pretty fast. And with search engines that we have now, when you put something in Google and this thing comes up of all these places where this person's name is mentioned, especially if you have a dates like the approximate time that they lived and when they might have died.
So I have an additional question, but I'll wait and go back in line.
Oh,
Thank
no,
you,
please.
Thanks.
Yeah, go ahead, Jim. You seem to be the only one. Yeah.
Oh, okay, great. And this has to be convincing municipalities to do takings of land of low value of owners unknown. What's the standard that they apply? So, land in the middle of nowhere where for as far as the public record goes back that we can track, it's always been unknown owner. And we would like to see it kind of have a conservation outcome. How do we convince municipalities, and what's their standard to
Well,
do
they can decide what to do or what not to do, obviously.
Yeah.
Incentivizing them, unfortunately, the biggest incentive I've seen is if they think there's going to be tax money coming in, which means it's not going to be conservation land, which is why I kind of go around them and do the other thing, look for it, look for the heirs of the owners from 150 years ago and follow them forward. And like I said, with all these genealogy sites nowadays, it's not as hard as you might think.
Well, Irene, let me say, let's say the land in question is surrounded by land dedicated to a conservation purpose, so it's never really gonna be developed. But we would like to see it added to the kind of the network of conservation interests that we're protecting.
Mm-hmm.
So is that a decision that each municipality makes on their own? Or is there
basically, and land of low value, they have to send it up to the Secretary of State to get approval that it's land of low value, although they have changed things to make it a little easier nowadays.
Mm-hmm.
But you basically have to either incentivize with something they want or need, or you have to get someone interested and curious, invested in which a lot of times I've been very lucky at that. By the time I'm done, they're as interested in finding the answers as I am in filling the holes. So, but it still comes down to whether the treasurer wants to go forward, how busy they are. If they feel there's no threat, if it's surrounded by conservation land, they're probably not going to be too incentivized because it's more work for them.
Well, sure. So, and is it the treasurer that makes the decision, or is it the town manager, board of selectmen, mayor?
I'd have to review the current law on it, but I think it's the treasurer that makes the decision. It's also the treasurer that makes the decision whether to put it up for auction, which is now that sounds like the perfect parcel for doing a request for proposals, where the town says, okay, anyone interested in this parcel, make a proposal, and it has to be for conservation. So you step in and you say, okay, I'm making a proposal and that I'm going to take on this land and whatever it takes, and I'll make it conservation land. And if worse comes to worse, you just have activities or control of it for 20 years so that any other interests are wiped out.
Great. That's very helpful. Thank you.
So yeah, I know you and I are getting older, but you'd be surprised how quickly 20 years goes by.
First, we have Abby, then Kate.
Hi, Abby.
Hi, yes, thank you. Thank you again. This is really interesting and helpful information. I'm wondering if you see, other than having the people there in person to ask questions to, do you see an advantage to actually going in person to the registry versus searching online?
Oh, definitely. Especially if I try to do as much as I can online at home, usually in my jammies on the couch. But then I go in and I find people very, very helpful, and they help with the brick walls that you're running up against. They make suggestions. But it's not the type of thing where you go in and you meet someone and then you call them 5 times the next month with questions. I think that if you go in there with your questions ready and get them answered, that is a good thing to do. And not only that, you have names of people, a contact. So if you do run into a little problem, you can call someone and see what they say, if they can help you.
Okay. All right. So the primary advantage would be forging relationships with the people there and having a good resource to talk to with questions.
And learning your way around. If they show you around and all the little secrets and nooks and crannies where things can be found, that's helpful too.
Okay, great. And do you still provide consulting?
I
To-
am retired and trying to stay retired.
Okay. Understood. Thank you.
Kate, you're next.
Yeah. I have a question, but I also have something to add about like how municipalities prioritize these tax title takings. At least in my experience, I've been able to develop a relationship with the staff people working in the department in Boston that does a lot of the tax title takings, and I've been able to say, oh, like. I've noticed this parcel has, I can see on assessing their backed taxes, and it's in an area that is like a priority for our conservation. And they are usually pretty, also because one of Boston's priorities, like coming from our mayor, is increasing conservation land. They're generally pretty agreeable to saying like, okay, yeah, we can, sort of move that one up in the queue, or we can focus on acquiring this. So it might be different when you're coming from outside of the city, but I think trying to figure out who the staff are that is doing that work and seeing, how you can go about getting it is like, it can't hurt. So that would be my advice there. And then my question is, a bit like earlier you had referenced like going and looking at old maps and things like that. What are you referring to, like any specific maps? Where do you usually find those? How do you start sort of getting into those and making sense of what they're showing?
Well, I was using historic aerials, which was really wonderful because they had all of the old USGS maps and all the old aerial maps from assessors. And you could overlay them and you could toggle back and forth to see the changes. But there is a charge for that. Another one is if you just look up historic maps in Google, a lot of stuff will pop up. And if you put the municipality that you're interested in, a lot of universities have some of these old maps. The Boston Public Library has a ton of old maps. And it's very strange, but like Hopkins in Massachusetts maps are out in Wyoming's and some library out there. But because of the internet that we have so much access to so many things, it's much easier to find them than when I used to have to run around physically to physical locations to look things up. But that's, if you put up in historic aerials, historic maps of, and you put it in quotations so you get the town and state in that you want, a lot of stuff will pop up. And links change. I mean, I'd give you a list of links that I use, but they change all the time. So I've gotten to the point where I just do a Google search and then see. Congress, there's a lot in Congress. There's a lot at the archives, the state archives in Massachusetts. So those are other places. And then there's old maps at every registry of deeds.
Great. Are there any other questions as we near the end of our time together?
Oh, can I just add one more thing for maps?
Yeah.
The land court that started doing land court registrations in the early 1900s, they have these huge assessors maps, as do most of the registries. And then they would mark out if someone wanted to register their property, say they had 100 acres, and they'd put a red line around it and put the registration, the land court registration number on it. And that's another one of my resources is I'll go there. And if there was a land court registration anywhere near where I'm looking, then you can pull the files. Well, most are in the archives now, but they did like title exams back 50, 100 years. And so you can find a lot of information there, plus what the court found. But sometimes it's just catch as catch can. You can get lucky, and some days you don't get too lucky. Sorry to interrupt you.
No, that's great. Anybody else? Any last question? Okay, well, seeing none, we'll look forward to following up by sending the resources to all of you who registered for today, the resources that Irene shares, as well as a link to the recording. And
I'd like to say how excited I am to be able to pass on some of this information to people, because I hope we have lots of people that are curious and want to find the answers to these puzzles like I do.
It's great detective work. Yeah. Well, thanks so much. This has been very interesting. Very much appreciate you volunteering to do it for us. Yeah.
Thank you.
All right.
Thank
Thank
you
you.
so much.
Thank
Take
you.
care, everybody.
Great
Enjoy
job.
your
Thank you
day.
so much.